in Gauteng, and she has another address in the Eastern Cape. It's only one house that has been verified so far because they were only arrested last night. Thank you, Worship. I was going to ask Worship for a period because I am in court on Monday and Tuesday. I was going to ask the Wednesday to come here, Worship, and deal with that. Report to the court as to what is our position at last.
And in respect of accused 2 and 4?
We have confirmed their addresses, Worship. Actually, number 2 has one address. We have confirmed it. Actually, number 4, the same, because it is not the first time we are dealing with him. Thank you, Worship.
And the stance on the
Bail.
release of accused 2 and 4 with regards to bail?
We don't oppose, Your Worship.
Not opposed?
No, Your Worship, we don't. For 2 and 4. For 2 and 4 years, Your Worship.
Anything else?
No, none, Your Worship. Thanks.
Mr. Exton?
Thank you, Major. Major, I confirmed that my limited this morning addressed me regarding these addresses. He confirmed this address is not on CIPC. This is a search that the police has done. We came up that accused 1. This address was connected to it. Now, I took instructions on these addresses, and clearly the state cannot deny that this is a fact, because if they're going to go and investigate, that this address does not belong to the accused. The first one was in Meyersdal, Ekurhuleni Estate. Now she confirmed that she leased a property there from 1 April to June this end in 2026. Bedford View address that they allege, she has never in her life stayed in Bedford View. She doesn't know how they get to say there's a property belonging to her. Now the state clearly doesn't have CIPC documents yet to say to the court, yeah, we say this is her address. They just say this is what we found in the system. What system? So, Bishop, with all respect, Waterfall Estate, she came and she says, yes, I agree. I had a lease there, September 2025 to March 2026. And then they've got another address of Sunwood Park. And she said, the Sunwood Park address was a house that they sold in 2000. So they're not longer the title holders of that address. But surely if you do a search, you're going to find out that that property belongs to them. Then they've got Brockman Estate. That is the address where she stayed. Now last night, the police were at this address. The police even, when my colleague of the legal team drove to the house to meet with the police, and it's this task team that is here.
Mr. Exton, do you mind just taking the
Sorry.
mic on the side, please?
Thank you. Now you should point, like I was on the point when my colleague went there to the house address. He found the police there. The police even assisted him. The investigating officer, it's a lady, Sergeant Madinga. She assisted my colleague to get clothing from the house of my client because we arranged to hand her over at Brooklyn Police Station. But we just wanted to get warm clothing, and that's why my colleague drove there. We didn't want to waste time to make sure that she can be brought to court in time. Now, regarding the Mpumalanga province, I mean, if you say there's an address in Mpumalanga but we don't know where, then this court accept that? Surely not. If they could come and say, no, in Mpumalanga, they're in such and such an address. But now it's like a fishing expedition. In Mpumalanga, we don't know where, but we will try and find out. Now, we should, with all respect, there's one address for the accused. these other addresses that she's used in these townships that we mentioned. My accused one had a threat on her life in 2023 already. Now, she reported the case to the police. According to her, nothing was being done to secure this threat that was against her. She then, out of fear for her and her family's sake, decided just to stay randomly at another place for safety. But at the end of June, she realized, okay, there's no one traced me, no one came to the house again, because the party was to come to the house, and that's what we reported the matter. And she said, now I'm staying at this system, this is my residence. This is the only property I possess, and this is. That is the address she stayed. We got it in our bail affidavit, and therefore we should all be respected. They don't say she's a flight risk or anything. She handed herself over, she cooperated with the task team when they called. She cooperated. If they now come to say these addresses, what is the purpose of following up these addresses when she declared? I declare, I just use it. That's what you're going to find. You're not going to find anything else. It's not properties belonging to you. So you should, in that aspect, I feel that they've got no other reason to keep her in custody, to go check addresses, and that we can proceed with the bail. And they don't oppose.
Sorry, this is also the address indicated on the J15.
The address on the J50 is exactly the same, the one in Brakpan. So that's why I say they knew exactly where she stayed. They went to that place. They didn't go to all these other addresses because I think they realized these other addresses were just leases. And now today they want to say, listen, we need to follow this up. No need to follow it up. And therefore I object that that postponement be given and her bail application not be notified. We are ready to proceed. I did give the state already a copy of the bail affidavit, and they didn't come back and say we've been opposed on any other reason. He said, I just should address the court on this basis. And the court are inclined to hear the bail application, they are free for they will do. Thank you.
And then Mr. Sorry, Ma'am Matsatsi, with regards to accused state.
Okay, Your Worship. Your Worship, I actually find it very surprising that when we, as University of my little friend, he was not going to proceed in the manner in which he's opposing this proceeding. However, this is the position that I shall find. Your Worship, the search and seizure that was conducted yesterday at around 4 was conducted at the address of accused number 3, which she owns jointly with her husband. It is the only asset that they have together, Your Worship. Now, Your Worship, when these incidents took place yesterday.
Sorry, just for the sake of clarity, this is the address in Bedford View.
That is the address in Bedford View, Your Worship. This is where the search and seizure occurred. This is where she was found with her children, her 19-year-old and her baby of 4 years. Your Worship, it is considered that there are 3 properties. The one property is rented out and it belongs to her husband, who is a business person. The other property that is being mentioned here by Malene Frank is a property at the parental home, at the rural home of the accused husband. And Your Worship will know that in terms of our culture, you will, if you are a male, automatically build around your parents. But that does not necessarily mean that that is their home. It is a home for the wife because she's married her, but for purpose of these processes, Your Worship, they only have one home, and this is where she was found yesterday. Your Worship, I do not see this as an obstacle for us to proceed before you with the bail application. The address has been verified and it is the sole address. Now, Your Worship, since her suspension from her employment, she has been at this address. She has been living at this address for a period exceeding 10 years. I think in my calculation it's something like 11 years. And prior to that, she had been staying in the property that is now been rented out to her husband's businesses for a period of about 7 years. I'm pleading with and begging with this court to proceed to assist us in this instance, considering the circumstances, personal circumstances that are briefly set out before this court, and which I intend to bring before you, Your Worship, in our bail application.
Mr. Mtoro.
Thank you. Worship, it seems as if it is common cause that they have more, they recently considered that they have more than one address. And Worship, I would like to take the court attention to the fact that if you have more than one address and they are not verified, that impacts on the likelihood to create justice. In case that he does not turn up, if they are on bail, then we will know where to look. That's why it is important, Worship, that we verify those addresses as to how they are linked to them. Thank you, Worship.
That the accused persons, one of three, will not stay with her.
We have that fear if we have that fear, Worship, for now, because we don't know how come they have so many addresses linked to them, and we cannot verify what my legal friend has put. Both my legal friend has put that he has already sold the other ones. We need to verify that indeed as to why they are still in their names. Thank you, Worship.
Well, I suggest, seeing that there are issues with regards to accused 1 and 3, and the state indicated that they do not oppose the release of accused 2 and 4.
Yes, sir.
That we, in the meanwhile, proceed with the applications for accused number 2 and 4.
Yes, sir.
I don't think you agree, Mr. Exton. I will allow all of you to say a question on this issue.
I'll just neglect first on the record that the reason why I also want to continue with the clarification is my client suffered a serious medical condition. She's suffering from hypertension, high cholesterol, poverty, a heart condition, diabetes, Worship, and she's got chronic back. The investigating team even knew about this, and this is why they arranged to detain them in Brooklyn Police Station. They know that she suffers from serious conditions and that she needs her medication. Now to say no, we can't proceed with her by application. We can maybe hear it in Wednesday. If we now check this again.
That is what I'm saying.
Yeah.
It's the island, the rule on
Yes.
the application in terms of section 50 subsection 6 with regards to obtaining this bank information.
Yes.
But I suggested because if I look at the time issue, at the end of the day, if we do not have sufficient time to deal with the issue in terms of section 50 subsection 6, it will mean that the applications for the ones who are not opposed will also not be entertained. That is the reason for my suggestion. I don't think you agree on this because I'm not saying as yet that I will grant the application in terms of section 50 subsection 6 or not.
Yes.
I just thought for in the interest of time we deal with the ones who are not opposed.
We should support this. I would say that we proceed that.
Can I hear the speaker?
Thank you. I'm glad to the court. On behalf of the accused group, Mr. Skenraj Prem Bahawi, I present an affidavit.
No, I'm not there yet. I'm not there yet. I'm still dealing with the situation of the court. Whether you agree with the situation or not, we will still get to the application itself. There are preliminary issues before we get to your application as well.
I'm in agreement with the court's suggestion.
Okay. Ms. Mutsatsi?
Your Worship, we are in your hands, Your Worship. We will abide.
Mr. Peter?
May it please the court, Your Worship. I do agree with the court's suggestion. I believe it's a prudent one. Your Worship, there is just one delay on our part. Following the engagement with the learned colleagues this morning during the course of the day and after receiving a copy of the charge sheet, we have effected certain amendments to the bail affidavit. I do have a digital copy of it with me, but my office is sending the hard copies on its way, Your Worship. We will be ready to proceed in a matter of mere minutes.
We will then proceed with the application in respect of accused number 2. Accused number 2, you may rise. The parties agreed and at Eden that Schedule 5 is applicable.
Result in you being charged and upon conviction be sentenced to a fine or 2 years imprisonment. Do you understand this explanation? And then I also need to inform you that anything that you say during these bail applications can be used against you and is admissible during proceedings, further court proceedings. Do you understand this explanation?
I do understand.
Thank you. For number 2, you may proceed then with the application.
Thank you, Your Worship. Your Worship, an affidavit in support of bail has been prepared and I agree to read the application. The affidavit into the record.
You may proceed.
I, the undersigned, Kemraj Prem Bahawi, with ID number 690715, 5258080, do hereby make oath and declare as follows. I'm the applicant here, confirm the contents here forward in my personal knowledge, and belief and unless otherwise indicated, they are both true and correct. The purpose of this affidavit is to place information before this honorable court in support of my application for my release on bail. I'm presently in custody and informed that I am facing the charges of fraud and corruption. I have been supplied with the charge sheet, but not the contents of the docket, and make these assertions on the strength of hearsay averments made to my legal representative and myself. I've consulted with my legal representative and appreciate the gravity of these charges. I'm aware that should I be convicted, I may face a serious sentence which may include my incarceration. My personal circumstances are as follows. I'm an adult male person aged 57 years old. I reside at house number 1218 Kirkby Street, Queenswood, Pretoria, Gauteng. I was born in Anzinto, province of KwaZulu-Natal. I attended school at the Anzinto Secondary School, passed my matric, and I subsequently obtained a B. Proc degree in April 1994 from the University of Natal. Also obtained my Masters of Law from UNISA, University of South Africa, in 2003. I am married to Deepika Bahari. We have 2 children. My son Keaton is aged 24. He's a law graduate, currently serving his article. He resides with me in my life. My daughter, Tinamika, is aged 29. She's employed as a property administrator in Victoria. I'm a South African citizen. I do not have family or friends outside the Republic of South Africa. I have on occasion traveled outside South Africa. I have traveled to Kenya during July 2025 at a short stop. I am employed as the head of legal and risk at the city of Ekurhuleni. I have been employed since 2013 in that position. So I've been employed in that position in various positions at the city of Ekurhuleni, having moved from different position to position. I have been advised that I have a duty to disclose any pending cases and previous convictions against me. I confirm the following. I have no previous convictions. I have no pending or cases outstanding against me. I have no outstanding warrants of arrest under my name. I have no protection orders. There are no arrestment orders, no domestic violence orders. I am not out on parole. I am not under correctional supervision. My attorney has explained to me, and I understand the consequences of my failure to disclose in the event I have any of these previous convictions, pending cases, or warrants outstanding. I respectfully submit that I have not made any threat of violence to any person. I do not harbor any resentment to any person as a result of these charges I am facing. I confirm that should the Honourable Court deem it necessary to grant me bail with certain conditions, I will adhere to those conditions. I confirm that I have no access to any evidential material which is to be presented at my trial, and in any event, I do not wish to destroy any evidential material. I confirm that I have no wish to discuss this matter with any state witnesses, and I will gladly refrain from making contact with any of the state witnesses should the court so require or order. I respectfully submit that I have not supplied to the state with any false information. I will not attempt to evade trial, and I know the consequences of evading trial, and these are that my bail money will be forfeited to the state and a warrant for my immediate arrest will be issued by the Honourable. I do not believe that the sense of peace and security of the members of the public or the confidence in the criminal justice system will be undermined or jeopardized by my release. I will plead not guilty to the charges against me at the subsequent trial. I have been advised by my legal representative that I have the right to remain silent and not to disclose the basis of my offence. I have been informed that the charge falls under Schedule 5 of the Criminal Procedure Act that the onus rests upon me to convince this Honourable Court that in terms of Section 60, sub A B11 of the Criminal Procedure Act, it is in the best interest of justice that I be released from it. I submit that I have discharged the onus, and I base this for the following reason. I'm a South African citizen and have a fixed residential address. I do possess a passport. Further in this matter, There is several ongoing investigations, which includes the Langa Commission, investigations by SCOPA, and litigation. My continued incarceration will hamper my defense and the ongoing litigation and processes that I am involved in. I have health conditions. On the 25th of February 2026, I underwent operations with 2 stents were implanted to keep the arteries to my heart open. I require medical treatment. I am on chronic diabetes and hypertension medication. I am not disposed to violence. I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk. At the time of my arrest, I did cooperate with the police. My family will be able to raise the appropriate amount for bail. I have no knowledge of any evidential material which exists with regards to the allegation leveled against me. In any event, I believe that whatever such evidence may be, it is in the possession of the police. It is safely secured. I do not have access thereto. I undertake not to interfere with any further investigation. I do not know the complainants in the matter. I am not sure which witnesses the state will rely upon in order to attempt to prove its case against me. Nonetheless, I undertake not to communicate with the witnesses, whoever he or she may be, and or any other person whose name is appear on the list of state witnesses should say be provided by the state. My continued incarceration will only prejudice me and create no benefit to the state. I respectfully submit that should I be released on bail, my release will not disturb the public order or undermine the proper functioning of the criminal justice system. I will comply with such conditions as the government of the court wishes to impose. I accordingly submit that it is in the interest of justice, the considerations of prejudice and the balancing of the respective interests that favor my release on bail. I therefore humbly request the Honourable Court to grant me bail in the amount of 5,000 rands. Attached to the affidavit, Your Worship, is a copy of the accused identity document, a copy of the marriage certificate, an original printout from the City of Tshwane municipal account in his name, account addressed to K.P. Bahari, for the address 1218 Curtis Street, Queenswood. He is the owner of this property and receives a rates account in his name. Further attached to the charge, to the affidavit, is but one of the processes that is referred to in the affidavit. The first is an invite from attorney for Pele Marke attorneys dated 26th of June 2026, indicating to the accused that he should attend a disciplinary hearing from the period 6th July to 10th July. These proceedings were underway yesterday when he was arrested. Attached to it is the charge sheet for that disciplinary hearing, and I refer the Honourable Court to read the charge sheet very briefly because it is almost a replica of the charge sheet that is pending before this court. And in essence, what this matter is, if I may address the court now that my affidavit is ready, these are the actions.
I will afford you an opportunity to address me further, like Mr. Arthur. Can I just confirm with your client, Mr. Perry, you may rise again, to confirm the contents of this affidavit, that is your instructions. You satisfied with the contents of this affidavit, and did you sign it?
I am satisfied, Your Worship. I did sign. I may have noticed just one minor change.
Then you can take it up with your legal representative. You may approach.
Thank you. Your Worship, is the indication on the affidavit that his son stays with him. He explains that his son, although it's a permanent resident, but where he works in Johannesburg. So he travels between Johannesburg and mostly in Johannesburg, he works. He stays there and then comes home on weekends. That's the
You confirm this, sir?
I confirm.
The sworn affidavit is then received and marked Exhibit A. Mr. Patel, are you going to call any further witnesses in this application?
no further witnesses. I can also just place on record that the accused has placed me in possession of his passport, and we are hoping that if, with his father's bail conditions, that the passport can be surrendered. Yes.
Thank you. That is then the application for accused or applicant number 2. In respect of number 4,
May it please the court, Your Worship. I'll be guided by the court, Your Worship. I still am not in possession of the hard copies of the affidavit, and of course it's not been signed by the accused. I am in possession of a digital copy which I am able to read in the record in the meantime, should the court so permit. And when the affidavit arrives, it will then be signed and commissioned out, and I can hand it up, Your Worship. Of course, the accused is before court, and you can confirm the correctness of the affidavit.
yeah, I'm also taking into account the time constraints that we currently dealing with, so I will allow it for now. Mr. Ekurhuleni, you may rise. Thank you. May proceed, Mr. Peter.
Your Worship, the document is headed in the magistrate.
Sorry, I just failed to just explain to your client also the provisions of Section 6011, capital B, that there's a duty on you to disclose any previous convictions or pending cases. Failure to do so may result in you being charged and be liable to a fine or to 2 years imprisonment. Do you understand this explanation?
Yes, Your Worship.
And furthermore, if you elect to testify during these proceedings, anything you say during these proceedings may be used against you during subsequent proceedings. Do you understand that it will be admissible? You also understand that?
Yes, sir.
Thank you. Then you may proceed.
As a court is, Your Worship, fortunately have it that I've just been furnished with the hard copy.
You can proceed.
All there's left to be done is for you to sign and commission. Your Worship, the document is headed in the Magistrates Court for the Magisterial District of Ekurhuleni Central, held at Germiston, case number D1414/2026, in the matter between Imogen Mabokane Mashazi and 3 others and the state. In the tramlines, its affidavit in support of the application for bail. The affidavit then reads, I, the undersigned, Julius Dr. Inkonazi, ID number 75112255648086, do hereby make oath and say that 1. I am an adult male employed by the Ekurhuleni Metropolitan Police Department, in brackets EMPD, as the Deputy Chief of Police and reside at number 22 Eugene Murray Street, Randhart, Alberton. 2. The facts herein contained are, unless otherwise stated, or unless the context otherwise indicates, within my own personal knowledge and belief, and are both true and correct. 3. Where I make statements of a legal nature, I do so on the advice of my legal representatives, whose advice I reasonably believe to be correct. 4. I am a South African citizen, the first applicant in the above matter, it's the fourth applicant in the above matter and the fourth accused in the main proceedings, and this is an application for my release on bail. The heading is Bail and Common Law and Constitutional Presumption of Innocence. Paragraph 5. I am reminded by my legal representatives, and which reminder I find encouraging, especially having regard to the considerable attention that this matter has attracted in the media and with the public, of the words of a former and late Chief Justice, Ismail Mohammed, in the matter of State versus Asherson, 1991, Volume 2, SALR 805, in brackets, an Avian Court decision, where our esteemed former Chief Justice remarked as follows. An accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. I pray that these words resonate with presiding officers seized with the deciding the fate of I and my co-applicants in the bail application. Indeed, I am refreshed by the attitude of the state in this matter, no doubt respecting the statement of our late Chief Justice in electing as conveyed to this court not to oppose my release on bail. Next heading is the charges and applicable schedule. Paragraph 6. From the paucity of the information that has been provided by the state to my legal representative, it appears that I have been charged together with my co-applicants with various counts of corruption. Given that I have not had any access to the police docket and am thus not able to make complete submissions in respect of what has been averred to by the state in the provisional charge sheet that has been provided, what I can and do categorically confirm is that I deny any suggestion of irregularity or impropriety on my part arising from the averments made in such charge sheet. 7. The state alleges that the offences with which I've been charged falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977. I am further advised that the determination of the applicable schedule is a matter of law and that my legal representatives may advance legal argument in this honourable court disputing the correctness of the state's contention that this is a Schedule 5 offence. This notwithstanding, this affidavit has been prepared on the basis that the provisions applicable to Schedule 5 offences find application. I respectfully submit that in this my affidavit, I more than adequately discharge the onus of proving that the interests of justice permit my release on bail. The next heading is History and Personal Circumstances, paragraph 8. I am presently unmarried and reside at my aforementioned address with 4 of my children. The property is registered in my name and I have a bond with Standard Bank Limited. I have resided at this address for the past 7 years, previously having resided at number 161 Sidwana Crescent, Fossil Risk, Extension 5, Katlehong, Thala section, which was my marital home. 9. I was born at the Natal State Hospital and grew up in Katlehong, Gauteng. I attended primary school at Kumalo Primary School. I later attended high school at Lekutula High School, where I eventually matriculated in 1997. After matriculating, I participated in various youth development programs throughout Ekurhuleni before gaining employment with the EMPD in about 2003, initially as a cadet. Following my employment with the EMPD, I've attended various skills development and training programs, which includes inter alia a military leadership life skills course, a military leadership development and communication course, and a specialized police weapons training course. 10. Academically, I have obtained a master's degree in public management from Regenesis Business School, Samson, Gauteng. I have also attended various other academic courses at Wits University and University of Cape Town. 11. My parental home is situated at number 728 Malana Street, Mavambela section, Katlehong, Gauteng, where I formerly resided with my father Titus Koko Mkonazi, my mother Florence Wane, and my brother Lawrence Mkonazi. My father passed away on 28 June 2009. My mother is a pensioner and still resides at my parental home. My brother resides at number 299 in Kala section, Katlehong, Gauteng. We are an extremely close-knit family. 12. I was previously married to Ethel Baliki Yali. We were divorced in about 2017. There are 3 children born of our marriage, namely 2 daughters, Kwawekwazi Mkonazi, age 21 years, and Kanya Mkonazi, age 11 years, and 1 son, Nklonipo Mkonazi, age 19 years. All 3 of my said children reside with me at my home in Alberton. 13. I have 5 other children born from previous relationships. 13.1. A daughter, Ndukutle Shabangu, age 31 years, who resides with me at my aforementioned address. Her mother, Zanele Shabangu, is late. 13.2. A daughter, Lesedi Ramasunya, age 19 years. She resides with her mother in Tabiseng Ramasunya at 7834 12th Street, Leondale Gardens, Germiston 1401. 13.3. A daughter, Lelutelu Safapi, age 16 years. She resides with her mother, Nontikilelo Slapi, at number 14 John Deere Street, Eden Park West, Extension 1, Alberton, Gauteng. 13.4. A daughter, Bushlebumbula Inshiba, age 14 years. She resides with her mother, Cynthia Inshiba, at Unit 43, Cricklewood Complex, Geordie Street, Malbarton, Gauteng. And 13.5. A son, Penyo Mashupia, aged 11 years. He resides with his mother, Bongani Mashupia, at number 5 Corner North Rand and Trickard Road, Boxburg, Gauteng. Although 4 of my children of ours do not reside with me, we share an extremely close relationship, which includes seeing and spending time with them on a regular basis. They often visit me at my residence and spend quality time together with me and their other siblings. I also contribute towards each of my said children's expenses and maintenance on an ongoing basis. 14. I have a valid passport that was issued on 18 August 2025. I have not used my passport since it was issued. However, I have previously traveled abroad on holiday and made use of my old passport. I believe that the state will confirm that in the bail proceedings in the Boksburg Magistrates Court, which I deal with later herein, it is in possession of my passport consistent with one of the bail conditions in such court. I do not have any close relatives or friends who live outside our country borders. I consider Gauteng to be my permanent home and indeed has been my permanent home since birth. I submit that I have long-standing and deep-rooted ties to the Gauteng community, both social and familial. Because of my strong ties and familial roots to the broader Gauteng community, I submit that it is highly improbable and indeed impossible that I will avoid standing my trial hearing. I further submit that I have good and stable family support structures. 15. Through my employment with the EMPD, I earn a monthly salary of approximately 65,000 Rand after deductions. I do not have any other source of income apart from my set monthly salary. I am the holder of a bank account with Standard Bank, account number 002209096366. 16. My assets comprise inter alia my home, which is worth approximately 2.5 million rand, and in respect of which Standard Bank is owed about 2 million rand. I have household furniture and effects which are fully paid and worth approximately 300,000 rand. I have been employed with the EMPD as stated above since 2003 and am due a considerable pension of around 7 million rand. I am aware that if I flee, I will lose all these benefits and assets. The heading is then health, paragraph 17. I am of ill health, having been diagnosed with type 2 diabetes in about 2021. I am on chronic medication to manage the said condition and other general ailments, which medication includes Colson, Sandoz, Aspervol, Tendia, Jalramat, Omniflux, Trepoline, and Puricos. My attending physician is Dr. Kuni Fenter, who practices out of Healthworks Medical and Dental Center, Boxburg, situated at Shop 14, East Rand Retail Park, North Rand Road, Everdy, Boxburg. Dr. Fenter can be contacted on 011-306-1300 to confirm any aspect related to a medical history and treatment. The heading is in previous convictions and any cases. 18. I have no other criminal matters that may be said to be pending against me, nor do I have any previous convictions, save for the following matter which is pending in the Boxburg Regional Court. I believe it common cause alternatively cannot be bona fide disputed by the state inter alia 18.1. In April 2026, I was arrested on charges of fraud, corruption, and defeating the ends of justice with my co-accused Mr. Rutla. Additionally, a charge of unlawful possession of ammunition was preferred against me. 18.2. The state opposed our release on bail, but on the 28th of April 2026, the learned presiding magistrate, Mr. Mukhampa, granted us bail in the sum of 30,000 rand, coupled with conditions that included the handing in of our passports. 18.3. I have religiously and faithfully complied with all the conditions imposed, including appearing in court on the various dates to which the matter has been postponed in the Boxburg Court. 18.4. Briefly, the state's case in this pending matter can in a gist be summarized that the state contends that Mr. Rutra was arrested on the 9th of March 2019 on a speeding offense and issued with a notice to appear in Boxburg Court on Monday the 13th of March 2019. To avoid appearing on the date given an important job interview on the same day, Mr. Lura paid on arrangements allegedly made by me, a state witness, Mr. Tsotetsi, a whopping 407,000 rand to appear in his stead. This amount was allegedly then equally shared with me. Respectfully, I submit that this speaks to the absurdity of the allegation against Rutla and I. To compound matters, we have since received the final charge from the state in this matter, where the purpose for which the alleged gratification of 407,000 rand is clearly shifted. 18.5. As part of the docket disclosure, the state has also provided the affidavit by the key witness Tsotetsi. The statement is fraught with contradictions and inconsistencies. More tellingly is the closing disclosures made by Mr. Tsotetsi purporting to give the reasons why he had decided to come clean. This only in the affidavit made on 16 April 2026, that is some 7 years after the event, and which reasons I quote verbatim from his affidavit, namely, as time went on, I realized that my actions, as well as the conduct of those involved, were unlawful and improper, and I resolved that such activities should cease. Secondly, I realized that I'd risked about my life for someone who is not taking care of me. I saved Mr. Rutra's promising career. Currently, he is the city manager of the municipality. According to me, the risk that I take about my life is unparalleled to what they give me. I'm saying this knowing that there is not fixed agreement between us before I agree to stand in for Mr. Rutra at court. 18.6. I submit that it has become even more manifest since the disclosure of the docket that the state's case in this Boxburg matter is dismally doomed to failure. I should add that in respect of the possession of unlawful ammunition charge, I had already explained at my bail hearing that the ammunition was lawfully issued to me in my capacity as the Deputy Chief of the EMPD. I am confident that the administrative exercise in confirming such fact with the EMPD system will confirm this. I mentioned that shortly after my suspension in November last year, EMPD officers attended at my residence and uplifted my state-issued firearm and other equipment issued to me by the department. Upon informing the officers of the ammunition in the safe, I was informed that the attending officers were not from the Armory Department and were simply carrying out the instructions of their superiors to uplift the said firearm and equipment. I was informed that an officer from the Armory would attend at my residence at a later stage to uplift the ammunition. I point out that in these circumstances, it would have been unwise for me to transport the ammunition to the Armory to hand it in. I submit that I have acted reasonably and prudently in the circumstances, regard being had also to the fact that for the last few months I have been challenging the lawfulness of my suspension. There is nothing in the police docket to gainsay this. 19. There are no protection orders, whether in terms of the Domestic Violence Acts 116 of 1998 or the Protection Act from Harassment Act 17 of 2011 that have been granted against me. I confirm that there are no applications for such protection orders pending against me in any court. In addition, I am not currently subject to any interim protection orders, nor am I bound by any conditions arising from such orders. The heading is then charges, arrest and defense. 20. I was arrested at my residence last night by a contingent of police officers. Candidly, as has widely been reported in the media, I had been a witness at the Madlanga Commission and arising from recent reports of the Commission had been expecting my imminent arrest on the charges herein, which I believed to be spurious and politically motivated. I had simply informed my legal team to be on standby for my imminent arrest, which I had been expecting for several days. 21. The state will no doubt confirm at the both arrests herein I fully cooperate with the police. 22. I emphatically deny any involvement in the charges being preferred and specifically deny having committed or having any prior knowledge or involvement of the commission of the offences in question. I expect once I obtain docket disclosure, in particular the various statements by witnesses and the like, I will be able to fully disclose my defense and rebuttal to any adverse allegations. I have no doubt that I will be completely exonerated in any trial. I wish to state that given the negative publicity that I have attracted in the media, I am of the considered view that a fully ventilated trial is the best vehicle to completely exonerate me of the charges and moreover completely clear my name in the public forum. 23. Though it is admitted speculation on my part at this stage, I believe that my arrests have been orchestrated by individual S for ulterior and nefarious political motives. It is no secret that I have made known my aspirations of applying for the position of Chief of Police, which office will become vacant at the end of the year. Of course, my arrest and prosecution negatively impacts my eligibility for the role, if not, in fact, barring me completely from being considered for such position. 24. I submit that clearly the state's case against me, as with the Boxburg matter where Mr. Tseteti is the key and indeed only witness to the actual alleged offence, is extremely weak, even without being further subjected to the rigors of the examination in a trial. I dare say that the narrative of the state's case appears more at home in disciplinary and or civil proceedings. 25. I am innocent of the said charges and intend pleading not guilty at my trial. Indeed, I expect with a great degree of certainty that once the political influence that have been brought to bear on the matter no longer prevail, the state will persist with such the state will not persist with such charges, though as stated before, I welcome and prefer being exonerated in properly and fully ventilated trial. Heading is Flightless. 26. I believe it will be common cause inter alia that I was arrested on both occasions at my place of residence, which is well known to the police given the nature and position of my employment. I am a public figure, having appeared extensively at the Madlanga Commission of Inquiries. My personal circumstances, etc., have become well known to all in Sanda. 27. My name and face are known to many, if not most people in our country, and indeed to many people in the world, given the widespread media attention that this matter and the Madlanga Commission of Inquiry has attracted. Indeed, even these bail proceedings are being disseminated all over the country, if not the world. In the circumstances, I submit that I am clearly not a flight risk. Clearly, the state confirms this. 28. I also believe it incontrovertible that I will not interfere with the investigation and or with any state witnesses. Respectfully, the state's position in not opposing bail confirms this. I should mention that I am suspended from, admittedly, my influential position as Deputy Chief of Police of EMPD. I therefore have little, if any, influence over the investigation and any potential witnesses. In fact, I do not know who the witnesses are. It is also important to point out that this matter is being investigated by a specialized task team on the one hand and prosecuted by specialist prosecutors from outside the province on the other. Clearly, the albeit unthinkable step of interference which a bail court may consider is unlikely, if not most improbable in this matter. 29. More pertinently, any possible fears on the part of the bail court, and I must emphasize that these fears would be ill-founded, in regard to the interference with state witnesses can satisfactorily be assuaged with suitable and indeed stringent bail conditions being imposed on my release. 30. I have no desire to flee from the police nor to avoid the due and proper administration of justice. I have respect for and full confidence in the South African system of justice and law courts and intend standing my trial hearing. 31. I have no desire to even contact any state witnesses, no potential state witnesses. Indeed, I do not even know who such state witnesses are. Again, I submit that bail conditions prohibiting communication with any possible state witnesses can clearly and effectively be enforced. 32. I have no desire to flee from the police nor to evade my trial hearing and do not wish to avoid the due and proper administration of justice. I will not commit any offences. I submit that there is no likelihood of me endangering the safety of the public or any person or indeed the public interest. I will certainly not undermine the justice system and will stand my trial and abide by any further conditions that the court may seek to impose. 33. I humbly submit that the interests of justice do not require that it remain in custody pending the final outcome of my trial, which I am informed may take many months to finalize. I undertake to attend court religiously and faithfully each and every occasion to which this matter is pursued until its conclusion. I further undertake to comply with each and every bail condition that the court may seek to impose should it see fit to grant me bail. 34. As regards the amount of bail, I am able to raise an amount of approximately 10,000 rand, but of course will be able to raise a further amount through loans from family and friends, which loans I will have to repay. I reiterate that I have already paid bail of 30,000 rand in the Boxwood matter. With respect, I do not believe that it is the quantum of bail that secures my return to court and compliance with any bail conditions, rather than the fact that I am anxious to assert and prove my innocence of all wrongdoing in this matter, and moreover, my full confidence in the justice system. 35. In support of the allegations herein contained, I annexed here to mark JM1, a confirmatory affidavit by Attorney T.N. Peters of my attorneys of record. The prayer then reads, wherefore I pray it may please the above honorable court to grant me bail as requested, coupled if need be with any bail conditions, including if need be the most stringent of conditions until the matter is finalized. Your Worship, there is just then only one annexure that's annexed to the affidavit, and that is a confirmatory affidavit by myself.
Thank you.
Your Worship, the affidavit has not yet been signed and commissioned. May I seek an indulgence to have it done now, or should I rather wait for the court to then deal with the request for the postponement by the state?
You can have it signed, and then you can deal with the commissioning of it. I'm just trying to save time here, because you would keep in mind there are still two applicants whose issues I still have to deal with. So in the interest of time, you can, let me just confirm with the applicant, Ms. Kwanazi. You confirm that the affidavit is in line with your instructions, you're satisfied with the contents thereof, and that you signed it. Yeah, sorry, you're about to sign it. Yeah. Sorry.
You should beg you to approach it.
Yeah, you can sign in the meantime. And
Thank you for the indulgence, Your Worship. This way you can
Thank you.
sign it.
And then are you going to call any further witnesses or present any further evidence? in
Nothing
this
further,
application?
Your
That is application for number 4.
Indeed so, Your Worship.
Upon its receipt will be marked Exhibit B.
As the court considers.
Mr. Mitiawa?
Thank you. Worship, in opening our case, I'm going to put on the record that we are not opposing the release of the truth. It was a postponing reasons. Any consent worship is going to be catered for by the bail conditions we are going to ask at this court. To your worship is that in as far as the interference with the evidence and the witnesses, we believe that they are not in the work premises anymore. They were suspended. So that mitigate the fact of interfering with the investigations or of the witnesses. I don't know if I can run with the conditions now, with the conditions that we would suggest.
Now, even though the state is not opposed
Yes,
to
sir.
the use, it still remains the decision of the court.
Yes, sir.
I'm of the view that it's in the interest of justice.
Yes, sir. Thank you, sir.
City Commission. Thank you, Your Worship.
Applicants 2 and 4 may rise. I'm not going to give full reasons for my ruling at this juncture, as we are all aware that we are pressed for time. We still have to deal with the issues of the applications of numbers 1 and 3. This is an application that resort under Schedule 5 of the Criminal Procedure Act, applicable in Section 60, subsection 11, small b, in which it is required that the applicants prove on the balance of probabilities that it's in the interest of justice that they be released. The state initially indicated that they do not oppose the release of the 2 applicants. The applications were brought on behalf of applicants 2 and 4, supported by sworn affidavits marked exhibits A and B. The court is mindful of the provisions of Section 60, subsection 11, Section 60, subsection 4A to E, and subsection 11. The court considered all the evidence tendered, and the court is satisfied that it is in the interest of justice that the applicants be released on bail. The application for bail is granted. That is in respect of applicants 2 and 4. Thank you. Now you can address me with regards to conditions and amounts.
Your Worship, my apology. Before my learned colleague begins, I beg you to hand up the signed and commissioned affidavit.
That is as indicated, Exhibit B.
As the court pleases.
Thank you, Mr. Chairman.
Worship, the first condition we are proposing, Worship, to the court is that the appeal number 2 to release his travel documents. Between 5 and 8 in the evening. Not to communicate with the Ekurhuleni municipality employees to discuss the evidence of this case. To inform Your Worship, that is the fourth one, to inform the investigating officer if he want to leave the province of GP or maybe going abroad to submit his itinerary to the investigating officer, then we will look at that. As far as accused number 4 is concerned, we have his passport already. And we have the same conditions to him as to when he wants to go abroad to just inform the investigating officer again. So there's also he can, if maybe he submit his itinerary, if he want to go abroad, then we'll see the duration of the time he will be away and for what purpose.
I'm just the question is,
Okay.
This is in respect of
Choose
4.
applicant 4, yes.
You said he already submitted his travel documents.
Yes, Worship, from the
And
other
now
matter.
You indicate to me if you want to travel abroad, you must submit. How is he going to travel abroad without the travel documents?
They are with us,
Yeah.
Worship. Maybe he gets something that needs him overseas,
Okay.
to just submit that itinerary to us. We will release the passport for the duration of that period if we see that it is reasonable.
You can apply to have his travel documents.
Yes, Worship.
returned.
Yes, Worship. For that purpose that is in the itinerary. Worship, coming to the last point, the issue of amount, the bail amount.
Mr. I would just assume that the order the conditions set as a bail condition for accused persons not to directly or indirectly communicate
With the witnesses. Yes, Worship. Yes.
Did that apply to both 2 and 4?
Yes, Worship, indeed.
You did mention that the number 2 not communicate with City of Ekurhuleni employees,
Yes, Worship.
which I would think is maybe any of the specific employees at Ekurhuleni, only witnesses, and I would assume that also you would know who those witnesses are.
Worship, let me try to be closer. The employees of the finance section in the Ekurhuleni and the employees of the human resources department. That is the gist of where our witnesses are coming from. Then, Worship, coming to the money, to the bail amount, Worship, the state suggests an amount of 100,000. Because, Worship, one, the amount involved in the commission of this offense is above $1 million when it comes to the applicant number 2. And for applicant number 4 is 653, the amount involved. 653,000. They earn, Worship. Let me start with applicant number 2. I did have a glimpse, Worship, at his payslip. Even though he is suspended, he is on pay. Still on pay. He is earning in excess of 100,000 without getting directly per month. And as far as applicant number 4 is concerned, Worship, I have also his I looked, Worship, at his June payslip. Worship, he is earning a nice sum of 140 plus per month. The purpose, Worship, of the hefty sums of money is to make it difficult for the accused to just forfeit it and then decide to leave. As a court decision, those are the conditions.
And then also, you can address me with regards to the amount.
Could I just get clarity on condition 1? There was an indication that we would release documents. I'm not sure what documents are.
Can you just address me? I just need to know what you are communicating with each other. Yeah?
I was meaning the passport.
Passport.
Yes.
Okay.
Yes, we extended the handover of the passport. We don't have any objection to that condition, that the passport be handed over to the prosecutor and investigator.
Ms. Nkelwa, should be handed to the prosecutor, investigating officer. Who is present?
Yes, he's present.
Should I make it an order? You're gonna volunteer to hand the passport over.
Volunteer to hand over.
You can hand it to the investigating officer.
It's recorded that it is in the possession of the...
It is recorded, Mr.
Thank you. So that need to be a condition of such. The reporting on a Friday, 5 to 8, also not a problem. We're not too far from the Brooklyn Police Station.
Brooklyn Police Station is the nearest police station.
the condition not to interfere with state witnesses, that I accept, but not to communicate in as far as the disciplinary inquiry. This I've indicated in the annexures attached to the affidavit for bail. That disciplinary inquiry commenced on the 6th. It had run until the 10th. It was interrupted by the arrest. We've notified the chairman conducting the disciplinary inquiry that the accused cannot attend today, but hopefully he will attend tomorrow, and he is being confronted by the very same witnesses in the disciplinary inquiry that would be witnesses in this matter. So to restrict him from communicating would be rather unfair. So my request is that the restriction carries the condition insofar as is necessary and required for the purposes of the disciplinary inquiry. We undertake not to interfere or communicate with witnesses insofar as it relates to that.
And with regards to the charges that he's facing?
Yes. We've now had access for the first time to the charge sheet, and we know the charges in the disciplinary. There's a correlation. The same persons that are behind the charges making the same allegations. So it's the same people. So we say, we accept that we will not interfere with persons from the finance sections, the procurement sections, I think we said also the loss.
The human resource.
But insofar as communication with them relating to the disciplinary inquiry, we should be allowed to do that. Because we will have to cross-examine, be approaching them during these processes.
Yeah, but
in a formal setting.
let me understand what you mean when you object to the request that your client does not communicate directly or indirectly with members of the staff of the finance section, human resources section, and procurement section of the Ekurhuleni municipality. What is your?
I say that the restriction should have a condition that insofar as it needs to communicate with these persons for the purposes of conducting his defense in the disciplinary hearing, that he needs to have that communication.
No, I would assume it is common sense that if those witnesses are part of the disciplinary hearing, that it is his constitutional right to communicate, if we can call it communication, but to defend himself in during those proceedings, and cross-examination will be part of means of putting his case before the tribunal.
I accept that one would consider that inimical in the processes.
Yeah.
I'm just afraid that when we get to that processes and that process has started, people are giving evidence, there is cross-examination being undertaken, and there's further witnesses or testimony of witnesses being led, that we are not told, hold on, there's this impediment. There's a bail condition that you cannot have that. Just afraid that someone else may interpret these proceedings differently. So my request to the Honourable Court is that if a rider to the condition is that unless it is in relation to
the disciplinary hearing,
yes,
yeah,
then there can be no misinterpretation.
yes.
And then informing the investigating officer to leave the Gauteng province.
He said wants to travel abroad.
Yes. Travel abroad or the Gauteng province, we don't have any objection to that. We have now handed the passport. So to in any event require the passport back. I see the investigating officer is smiling and he's returned it to me, but I undertake to give it back to him when he's ready to receive it.
So it was returned.
He is returned it now, without an application to return.
With regards to the suggestion by the state that bail be set at the amount of 100,000 rand,
I think that's shocking. I think that's no justification that a person who's got a fixed address, who's already defending processes, who's given his full cooperation to the police, who's stood here today and conceded that he's not a flight risk, he's not a risk for the administration of justice, that he should be further limited to exercise his right to bail, to be almost hampered in the exercise of that right with an amount of 100,000 rands. I respectfully submit that that cannot be. We have tendered an amount of 5,000 rands. However, one must then give credence to what the prosecutor says. This is a serious charge, but I don't think it justifies or warrants an amount of 100,000 rands for purposes of finding some balance or equilibrium in these proceedings. I understand that the same prosecutor has in previous matters almost similar charges conceded to an amount of 30,000 rands. So maybe to bring fairness and equity, an amount of 30,000 rands would then, in my submission, be a fair reasonable amount.
anything else?
Thank you, Your Worship. Nothing further.
We're just looking at the time that we still have at hand, and keeping in mind the issue with regards to applicants 1 and 3. And also keeping in mind that the it's arranged that we proceed on, not arranged, but the suggestion is that we proceed on Tuesday, Wednesday, next week. Mr. Eckstein and Ms. Sassi, just allow me, I just want to deal with the issues of number 2 and 4 at this juncture, and then I will revert to the situation with regards to your clients.
Thank you, Bishop.
Wednesday will be the 15th. I'm just thinking of something now. I just remembered you haven't had an opportunity to address me.
Indeed, so, Your Worship, I was waiting patiently.
Because I'm thinking of the time issue, Mr. Peter. You can address me with regards to the bail condition. If I'm not mistaken, it was for your client to inform the investigating officers should he intend to leave the country and go abroad.
Indeed, so, Your Worship, my understanding is exactly the same, that was the only condition suggested by my learned colleague. We have no objection to such condition being imposed, Your Worship.
And then with regards to the amount suggested by the state of 100,000 rand,
Your Worship, with respect to the state, there is no evidence before this court to justify a quantum of 100,000 rand. The contrary is true, Your Worship. The accused has tendered evidence in the form of his affidavit setting out his personal circumstances, financial affairs, and financial obligations. An amount of 100,000 rand is something that the accused can ill afford. The court has already ruled that it is in the interest of justice that the accused be released on bail. However, if the court is to now grant bail in a quantum of such an exorbitant amount, it would be tantamount to the court refusing the accused release on bail, Your Worship. It is not an amount that is justified by any evidence that is before this court. Yes, the quantum of the value involved in the alleged offence is a consideration, but it is only one consideration that is to be taken into account, Your Worship. The court needs to consider the matter on the totality of evidence before it. And I submit that on the totality of evidence before the court, a quantum of 100,000 rand is not justified, neither is it in the interest of justice. Your Worship, I respectfully submit that the quantum of 10,000 rand, as so proposed by the accused in his bail affidavit, is fair, reasonable, and will secure his attendance to court, as he is on bail in another matter where he's already paid bail of 30,000 rand, where he has indeed attended each and every appearance, Your Worship. So there is no risk of the accused not attending his appearances in this matter. Unless there's anything further or anything specific the court wishes me to address it on, those are my submissions, Your Worship. But before I conclude, I see that when I handed up the signed and commissioned affidavit, the last page fell loose, Your Worship. Thank you.
Thank you. Thank you.
As the court please.
Before I postpone the case in respect of the accused 2 and 4, I am mindful of the issue with regards to the available time to proceed with the applications in respect of 1 and 3. Mr. Taylor, you indicated that your application for postponement in terms of section 50 subsection 6 is to obtain information with regards to the addresses of 1 and 3. Is that the sole purpose?
But there are minutes and they are wider cards. That's the problem that we need so many days.
Mr. Eckstein and Ms. Tsatsi, of course, the court cannot rule that you do not bring your application in respect of 1 and 3. They have a constitutional right to apply for bail. So the only issue that I sit with at the moment, I consider the application made by the state in terms of section 50 subsection 6. But even if we proceed now at this late hour, I don't foresee that we will be able to deal with the application of both in any event. I don't know if you want to just address me with regards to you indicated, both of you indicated in fact that you are ready to proceed with the applications today.
That is correct, Commissioner.
Yeah. Because I also have to consider that if I postpone this case today in respect of the ones that's going to be granted bail.
This is a suggestion that I know this late time the court isn't closed. Even if we proceed, bail needed to be paid, and there's no way that we can pay
that is the one issue that I also considered.
Yeah, but if I can request that we then roll this matter till tomorrow and proceed tomorrow, not the 15th. That's too far. The task teams has got many members. These addresses that they say so that it belongs to accused 1. They can drive to it. It's here. It's all in this area. I would say in the 50-kilometer radius. It's not out of this province that I need a day to go and check that address. I need a day to do that. This is in a 50-kilometer radius. They are task team. They are many members. They can ask their colleagues, listen, go quickly for me to this address, confirm who stays at this address. And then they're going to find out exactly, the accused said, I lease these properties for a period. They will not be able to rebut that. They're not going to find that. So, to keep the accused now in custody for 6 days, just to go and verify and then come back to this court and say, oh indeed, it does not belong to that. That would be totally unconstitutional. If we can roll it till tomorrow, we should, that we proceed tomorrow.
Mr. Taylor?
Your Worship, if I may proceed before the questions.
Okay.
Your Worship, I also want to echo the sentiments of my learned friend. Your Worship, we're dealing with what is called a special task team. It's a team that's supposed to be having as much resources, and that is why, Your Worship, they were able to conduct the session sealed yesterday without any problem, Your Worship. We believe that this team is capacitated enough, Your Worship, for Your Worship to rule that this matter then rolls over to tomorrow. They can do the work today, as they did yesterday, or the work can actually be done be done by tomorrow, and the letter can then be had later on in the day. Your Worship, it will be very, very unfair, especially with the circumstances of my client, with a daily of 4.
Thank you, Worship. Worship, it's my submission that something at this matter to next week for the benefit of their kids. In this way, the applicant one did submit to me her bail application, her affidavit. She did not deal with these addresses at all, and that was, that is not in her benefit. So if now we come with other addresses that she did not mention, it's going to be the problem.
In the issue of the addresses, your fears be curtailed by bail conditions.
What if we don't even know as to what are the living conditions in those addresses? What if it is a place for another crime that is being committed?
Mr. I don't want to get the impression that
Yes, Worship.
I don't respect your the reason for your postponement.
Yes, Worship.
We need to bear in mind that, as you will be well aware, the accused person before court is presumed innocent
Indeed, Worship.
until the day of guilt is proved. I also need to consider the situation.
Minus. So those are all the considerations that I need to take into account when I just decide to postpone the matter for almost a week. So there was a suggestion that we roll the matter until tomorrow to deal with the application in respect of the remaining accused persons, and that you by all means try to get confirmation with regards to the addresses. But you indicated previously that your fear is that they will not stand at trial, that they are a flight risk because of the issue of the address. And that's why I'm asking you, was it the only reason for you applying for postponement for almost a week?
And then the other is a question of us being able to do that exercise. I do understand what the court is saying.
My team is nothing but let's consider come tomorrow and see how far they can go with the application.
I can turn it down availability
The-
for the seat.
Yeah, the main role play is that we, in any event, want here tomorrow, taking into account that there's going to be an application, will be yourself and Ms. Potsachi.
Correct.
Mr. Butler and Mr. Peter, if you yourselves cannot be here to make available legal representatives to stand in on your behalf tomorrow.
Your Worship, I am available.
I'll ask my colleague or one of my colleagues to stand in for me and communicate the dates with you. My client to communicate the dates with me. Court will excuse me.
Thank you. Can all rise, accused 1 to 4. No, I mean accused 1 to 4, the accused person. Yeah.
If we come to order, can we start maybe later at 11 is fine?
Yeah. I don't know the legal representatives. Will you?
Your Worship, I'm available the whole day.
Yeah, you should, there's no need to start late, but I'm just scared that we run out of time.
Yeah. Mr. Superior.
I'm in the court's hands, Your Worship.
The matters, the application in respect of accused 1 and 3 is then adjourned until tomorrow. The matter, as I indicated, is then adjourned until tomorrow morning. Bail is granted in respect of accused 2 and 4 in the amount of 50,000 rand each on the following conditions. 1, accused 2 to submit his travelling documents to the investigating officer before the end of business today. Accused 2 to report to Brooklyn Police Station every Friday as from tomorrow the 10th. Yeah, that will make it difficult now because I wanted to state that still possible. As from tomorrow, the 10th of July, between 5 o'clock in the morning and 8 o'clock in the evening until this matter is concluded. Accused 2 is not to contact employees of the City of Ekurhuleni municipality attached to the finance section, human resources section, or the procurement section unless with regards to the disciplinary inquiry. 4, accused 2 to inform the investigating officer before travelling abroad or to leave the Gauteng province. And 5, accused 4 to inform the investigating officer before travelling abroad. Accused 2 and 4, you understand these conditions. If you fail to abide by these conditions, the state can bring an application that your bail be declared forfeited to the state and that you be remanded in custody. Do you understand? The matter is then postponed until tomorrow, the 10th of July 2026. Accused 1 and 3 remanded in custody.
Opposite, Your Worship.
Sorry? Is it accused 1 and 3 to
The Brooklyn SABC.
Brooklyn Police Station?
That's correct.
Yes.
Yeah, the J7 will then be endorsed that the accused 1 and 3 be kept at the Brooklyn Police Station until tomorrow morning.
As the court, please, as usual.
Your Worship, my apologies. Before the matter is adjourned, I see the time now. Can I inquire whether the bail office is still open for
I don't know.
bail?
We'll have to
Because
inquire
if
from
it's
the
not,
clerks.
maybe then not asked that the accused also, the J7 for the accused number 4, also be endorsed to be kept at the Brooklyn Police Station, Your Worship.
Mr. Ikero, I don't know if you can assist the court in that regard.
That's inquired from my from my colleagues. I just I go through the warrant to be cancelled by the court. There was they have been executed, and there is an endorsement as to where and when.
Yeah, is there an objection if the court then we can order that be endorsed that accused 2 and 4 also be kept at also at the Brooklyn police station?
Indeed, so, Your Worship. Your Worship, as one of my learned colleagues is notifying me that the bail office is indeed closed. So we, in effect, we'd only be able to make payment to bail tomorrow morning.
Mr. Mkeba?
No,
So the 1, 2, 3 and 4 be kept at the Brooklyn police station until tomorrow morning.
As the court pleases, Your Worship.
Here's the court book. Do we have the court book for me? Yeah. So I will join and then Melissa, can I take it with and you bring me the book or what? Okay, bring it to me when you're done. Court adjourned. Bring it to me quickly.